Good afternoon and welcome to the law. This is your legal light. It is your health law. I'm Samson Ladi Anyenini. This afternoon, I have three lawyers joining us to understand if criminal libel is alive in Ghana. Is speech being criminalized in Ghana and without basis? In 2001, July, Ghana repealed criminal and seditious libel. So why are we today, 2022, talking about reintroduction of criminal libel as police begin to prosecute a number of persons, including journalists, for speech offenses? We'll be right back. You're welcome back. This is Newsfile. This is the law. It is your health law and your legal lights. Never made this slip on this show. Anyway, so thank you very much. And as you know how we do it on this program, in due course, you will have the opportunity to join to ask your questions to our panelists. But let's begin with the Law 101. And the Law 101 is a segment by which we introduce the show, introducing you to a particular provision of the Constitution or a legislative instrument, an act of parliament, whatever you call it, and then give our guests 2 minutes each to explain that provision, so that by the time we are done with the show, if you forget everything, you don't forget the Law 101. This is how we seek to empower you. So what's the Law 101 for today?
Clause 1. All persons. Article 21. Freedom of speech and the press. Clause 1. All persons shall have the right to a. Freedom of speech and expression, which shall include freedom of the press and other media. b. Freedom of thought, conscience and belief, which shall include academic freedom.
Right. So our guests this afternoon are Ifia Amponsah-Mensah, who is a lecturer at the UPSA Law School. She's right here with us in the studio. Good afternoon, and thank you for joining us.
Good afternoon. Thank you for having me.
Great. Joining us via Zoom are Professor Kweku Asare, Stephen Kweku Asare, Professor of Accounting at University of Florida, Attorney at Law, Florida, Bar, and CDD Ghana Democracy and Development Fellow in Public Law and Justice. Thank you so very much for making the time to join us, Professor Kweku Asare. Okay, we need you to unmute. We didn't hear you. Great, we can hear you now.
I will say thank you, Samson, and good afternoon, and thanks for having me on the panel.
Thank you very much. We are privileged to have you. And also joining us is Justine Povara Tarewaja, private legal practitioner and a law lecturer. Thank you for joining us, Justine.
Thank you, Samson, for having me.
Great.
And good afternoon.
Great. So now let's take your views on our Law 101 for today. Let me begin with Justine. What will be your explanation in 2 minutes or commentary on our Law 101 for today? The Law 101 for today.
I didn't get the question quite clearly. If you can help me understand the question.
Okay, so I'm asking about the Law 101 for today. And in our Law 101 for today, basically talking about the freedom of speech, including academic freedom and that of the media, which you see on the screen. In 2 minutes, what will be your explanation or commentary on it for the understanding of our viewers?
Well, we in Ghana have how do I put it? We've embarked on a democratic path, kind of Western-style democracy. And typically in a democracy like that, there is freedom of speech, and it is being guaranteed by our constitution. And the background to it all is that we are a colony of Britain. And we take after the British tradition in many, many things, in our law, and we are a common law country. So it's against that background that we have to situate this discussion today, that there is freedom of speech, as you have even read the constitutional provision concerning freedom of speech. And whilst the MPP was in opposition, that was during the era of the Rawlings administration, there was so much talk about the criminal libel law, and the current president was in opposition with the MPP, a leading figure of the MPP back then. Now, there were several cases that they took to court and challenged, trying to expand the boundaries of the law. One of it was the case of the Republic versus Tommy Thompson Books Limited. It went to the Supreme Court, and the issue of criminal libel came up. And it didn't go the way the current president expected it. So then the party that he belonged to resolved through their campaign at that time that if they came to power, they will repeal the criminal libel law. And indeed, they won in the 2000 election. So 2001, President J. Kufuor was sworn into office. So by July 2001, the current president, then as Attorney General, he presented a bill in Parliament, and they had the numbers. It went through the bill. Of course, eventually the opposition, with initial hesitation, eventually voted in support of it. It was passed, and several provisions in our Criminal Offences Act were repealed from Section 101, I think, all the way to 119. And all of these concern criminal libel. So the criminal libel law was repealed by that, and it expanded the boundaries of freedom of speech since then up to now.
All right.
These are my initial comments.
Okay. Thank you very much. And so let me remind my guests that we're sticking to Article 21, 1A and B for the Law 101. And it says that all persons shall have the right to freedom of speech and expression, which shall include freedom of the press and other media, freedom of thought, conscience, and belief, which shall include academic freedom. Yes, Ifya, what do you say about this provision?
Okay, so Article 21 talks not only about the freedom of speech and expression, but goes on to list other general fundamental freedoms that are available, or that every citizen or every person is afforded. Now, if you look at the amendment of the Constitution, you go to Article 290, it talks about how entrenched provisions can be amended. And it states that this particular article is an entrenched provision. So when you say an entrenched provision, you're talking about something that is ingrained, something that cannot easily be changed. And the reason why, the effect of it being entrenched is that it provides some added protection against and gives a sort of robust or rigorous kind of process of amendment. So you see here that it's exhibiting the importance of the freedom of expression, freedom of speech, freedom of the press. And so our constitution, our 1992 constitution, is sort of telling us that this is very important to us as a democracy. And we shouldn't take it lightly when we are talking about freedom of speech, freedom of press, and freedom of expression. Yes.
Thank you very much. Professor Kukwasara, what do you say?
Add to what your guests have already indicated, this is probably one of the most important provisions in the Constitution. And as you can see, the provision vindicates the right to self-autonomy. People are free to think, they are free to believe what they want to believe, they are free to talk, they are free to wear T-shirts that communicate whatever their feelings are, because it's not just about speech, it's also about expression. And when we talk about expression, we mean expressive conduct, like wearing a tattoo is a type of expression. Now, inherent in all that is the notion that any of these things cannot be restrained on a proud basis. So there's no proud restraint, there's no censorship. You can say it, you can do it, you can believe it. Nobody has the power to restrain you from doing those things. And then secondly, once you've done those things, you shall not, unless the law allows it, be punished for your expression, for your beliefs, and so on. So there are at least three key concepts. One, no prior restraint on speech or expression or belief. Two, no post-speech or expression punishment unless expressly allowed by the Constitution itself or by some other law. And three, the reason for all of this is to vindicate self-autonomy, and four, to oil the engine of democracy and constitutionalism, because you cannot be truly democratic and you cannot be truly operating a constitutional regime if people cannot freely express and freely believe and freely articulate. In the case of Ghana, we need to always put it in a historical context, because we've come from very far in the era of PDA, where people like Akoto and others, J.B. Dankwa and others, found themselves in trouble for sometimes speech, although depending on what you read, they tell you that maybe they did something more than speech. But generally, it was dangerous to talk. And if you were a parent, you were even afraid of what to say, because there might be a young pioneer around, and the young pioneer might report you to some other person. To the Abbott case, where people like Dumogan had troubles because they questioned the propriety of the contract that the government had signed with the Abbott labs. To, if you come to 1969, people like Cameron Dodu having problems because they questioned the government's stance on South Africa, to more recently the culture of silence that permeated the polity, and which was very critical to what the framers of the Constitution had in mind when they were writing that clause that we just read, or provision that we just read, Article 21. Now, I must also add that, like every right, Article 21 is not absolute, but that doesn't mean you can do anything. You have to follow law, you have to follow the Constitution itself to make sure that any restrictions that you impose on those rights, because they are fundamental, because they are entrenched, meet constitutional muster.
Okay, thank you very much. And so that's some education for you on Article 21, Clause 1A A and B. It says, all persons shall have the right to freedom of speech and expression. And Professor Kokwasari has made the distinction between speech and expression, which shall include freedom of the press and other media, freedom of thoughts, conscience and belief, which shall include academic freedom. So please remember that according to the Constitution, you have these freedoms to enjoy. And like Ifya explained, this forms part of the entrenched provisions of the Constitution 1992, meaning the framers of the Constitution place this as one of the very important provisions of the Constitution that people should not toy with. Now, let's get to our question for today. Is criminal libel alive in Ghana? As you may be aware, there have been some 4 arrests so far, people facing the courts for false publication of false news and offensive conduct. And we will not add the man in contempt who is in jail now for 14 days. I will not add the treason felony issue of Oliver Barker Vomawo. So this has brought concerns, and people are saying that there is a reintroduction of criminal libel in Ghana. Once again, let me start with Justine. What will you say about these concerns?
Concerns that there is a reintroduction of criminal libel law in Ghana?
Yep.
Well, if there is law, we all know the processes that law pass. I mean, the legislation must, how legislation must be passed. For me, I would say I'm not aware of any legislation that has gone through Parliament and been printed by Assembly Press that concerns criminal libel. As I said, the current president was the Attorney General in 2001, but then I was finally in law school. When the sections 112 to 119 of our Criminal Offences Act were repealed by Act 602, which was passed by the Parliament of that day. Now, since then up to now, I'm not aware of any legislation that has gone to Parliament and has passed and got presidential assent to reverse what had been done way back in 2001. Now, if there are happenings that today people are likening to things that happened before that law was passed, fine. But as for it being said that criminal libel law has been reinstated, then that may be a bit of an exaggeration.
Okay, so a journalist made the publication of false news. He alleged that on Facebook that the president, the relatives of the president used the presidential jet on a shopping spree in the United Kingdom. That gentleman has been arrested and is facing the charge of publication of false news and offensive conduct conducive to the breach of the peace. He was granted bail in the sum of 50,000 Ghana cedis. Another guy, a journalist, quote unquote, because there are people who have questioned whether he's actually a journalist trained, so to speak, but that's not the issue for now. He said on his radio show that the First Lady, Mrs. Rebecca Akufo-Addo, and the Second Lady, Mrs. Samira Bawumia, have given to themselves, that is through unlawful means, state lands at the AU village around the Kotoka International Airport for the construction of the Rebecca Foundation. This gentleman is also put before court for the offense of publication of false news and offensive conduct, granted bail in the sum of 50,000 Ghana cedis. A couple had happened before this. This is why people say there is the reintroduction of criminal libel in Ghana. What will you say?
Well, as I said, that may be a bit of an exaggeration. Something you and I as lawyers know that libel is a particular, it has a particular definition. Even the section that you have mentioned as the section under which the people have been charged, they are not being charged for libel stricto sensu or strictly speaking. They are being charged for having committed other offenses, allegedly, of conduct conducive to the breach of the peace and kindred offenses like that. Though it looks a bit, it's a matter that I will not comment because it's in court, I will not comment too much. But it is not libel, strictly speaking. People may say, look, it kind of reminds one of happenings that occurred before the criminal libel law was repealed. I will agree. Because then, and we must also understand that it was the current president who led the charge for the repeal of the criminal libel law so that media freedom will be enhanced. And one of the arguments that the current president made at that time in opposition and whilst as Attorney General was that if people are defamed and they want a remedy, there is the civil remedy, which is litigation by way of defamation suits. Now, this is the same president who is now, the same Attorney General who is now president. And funnily enough, criminal charges are being preferred against people along that line. So if people want to accuse the government of double standards or anything of that nature, fine. But to say it is criminal libel, I disagree.
Okay, so what we do on the law is to do sort of a pure legal education. It's the reason I'm not mentioning specific individuals' names and the rest of them, so that we do the education without ending up doing the very usual things that's happening in this country. Everything must have some political coloration. So I'm coming back to you. I want to have Efia help us with something before we come to you. You are saying that sections 207 and 209 of the 208 of the Criminal Offences Act, which are the sections under which persons are being charged and bringing about the concerns of reintroduction of criminal libel, are not, and you qualified it, I'm glad you did that, stricto sensu criminal libel issues. But are they not questions of speech offenses? Section 207 says, a person who in a public place or at any public meeting uses threatening, abusive, or insulting words. Then section 208 says a person who publishes or reproduces a statement, rumor, or report. So this clearly has to do with speech offense. What therefore is libel or criminal libel?
Okay, so when you look at the repealed law and you see the definition of criminal libel, what we're talking about there is publishing of defamatory matter. And writing, effigy, painting. Once you print something that is defamatory, either if you intended to do so or you negligently did so, you are guilty of criminal libel. That's the repealed law. Now 207, 208 has, and these ones have certain elements.
Okay.
So we have the fact that a person makes threatening, abusive, or insulting words or behavior. This person does so in a public place or at a public meeting. And then the words or the comments or the actions of this person is likely to cause, as it were, a breach of the peace. So you see these three elements there. And criminal libel strictly is, as soon as you publish it, you are guilty of criminal libel. Once it's defamatory, whether you intended to do so or not. But here we are seeing that it's going a step beyond just publication. There's publication, there's the insulting words, and then the last part is also the capability of breaching the peace or provoking a breach of peace or causing fear and alarm. So these three elements are present in 207 and 208, but in the repealed law, we have simply, you publish defamatory matter, you are guilty of criminal libel.
Okay, and a defamatory matter must be a matter that is false.
Yes.
And in 208, as we have it now, it's about publication of false news. Except that that publication must be likely to cause fear and alarm to the public or to disturb the public peace.
Yes.
So what's the difference really? If you take 208, 207 against the laws that we have repealed.
Okay. If someone makes a defamatory statement against you, as the previous speaker Justine said, there are other avenues that are available to you. You have the civil remedy. So you can sue the person for defamation. The issue here really is the presence of the fact that it's being criminalized. And why are you criminalizing something that can be done in a civil suit? Is it because the person may be of a certain field, from a certain field, maybe the person is a public figure, or it's actually what you said that we are criminalizing? So the difference between the repealed law and this 207, 208, in my opinion, is the addition of the fact that it is causing, or it's likely to cause, some public disturbance of the public peace, or cause fear and alarm.
Or occasion a breach of the peace.
Or occasion a breach of the peace.
Okay. Now, I don't want us to forget that whilst we repealed the criminal libel in 2001, in 2008, we passed a law. It's called the Electronic Communications Act. And in section 76, it says, a person who by means of electronic communication service knowingly sends a communication which is false or misleading and likely to prejudice the efficiency of life-saving service or to endanger the safety of any person, ship, aircraft, vessel, or vehicle commits an offense and is liable on summary conviction to a fine of not more than 3,000 penalty units or to a term of imprisonment of not more than 5 years or both. So, Justine, first, let's hear from Efia whether this is any different from these two sections, 207 and 208, and whether they also carries the semblance of what we have repealed.
Well, so for section 76, if you check subsection 2, it talks about you not knowing whether the statement you made was false or not, and the fact that you may not have done, as it were, a background check, or to find out or to verify the information that you are putting out there, which is very similar to 208, when it says it is not a defense to a charge under subsection 1 that the person charged did not know or did not have reason to believe that the statement, rumor or report was false, unless it is proved that prior to publication, that person took reasonable measures to verify. So you see a certain similarity in that case, where if you make a statement, and the statement happens to be false, you are still going to be charged. You are found guilty of having made that false statement, even if you did not know that the statement you were making is false. And that's how I think it ties in.
Because you ought to have known, you ought to have taken steps
exactly,
to verify.
To verify that statement.
All right. Now, before I go to Professor Kukwasari, Justine, I said I'll return to you after we went through these three sections of these two laws. Substantially, can you say that there is any difference between these laws and what we repealed?
Between sections 207 and 208, as compared to the repealed criminal libel provisions? Is that the question?
Yes, please.
Oh, there's a difference. The repealed provisions clearly concern libel. And I can read the definition of defamatory matter in section 114, subsection 1 of the repealed provision. It says, a matter is defamatory which imputes to a person any crime or misconduct in any public office, or which is likely to injure him in his occupation, calling, or office, or to expose him to general hatred, contempt, or ridicule. So even in that particular case of Republic versus Tommy Thompson Books Limited, the issue was Nana Kunedu Ajima Rawlings was the first lady back then, and there was a defamatory matter published against him, for which reason the Tommy Thompson Books Limited, among others, were being prosecuted. Now, the matter went to Supreme Court, and the issue was whether Nana Kunedu Ajima Rawlings qualified as a public officer. So then, when you look at it, clearly, the criminal libel law had a particular objective and focus, which is clearly missing in sections 207 and 208. Now, the president, as we speak today, is the #1 public officer in Ghana. So we can, if the criminal libel law were still in force, then clearly that could have been used to protect him. But the provisions that we are talking about today, sections 207 and 208, there's no requirement of protection of a public officer from being defamed. So in the first place, clearly, when you compare the two, there is very clear difference. One clearly concerns defamation of a public officer. This one is a general law that can protect any Ghanaian. And for me, I don't see sections 207 and 208 as necessarily being about defamation and libel and things like that. Now, once I was in the police service, I'm an ex-police officer, and once I was in the police service, we used these provisions a number of times. There are some times some people just misbehave in certain public places to cause trouble. And it may not even concern public officers like we are talking about today. And those people had to be charged for that type of conduct that will encourage more people to fight in a public place. So it is a general provision that can be put to good use.
Yeah, so my question to you, my question to you is there a substantial difference
between
if the repealed provisions were speech offenses and these two provisions, including what we did in 2008, the Electronic Communications Act Section 76, are also speech criminalizing provisions? Can you say that the difference is substantial, if any?
Yes, there's a difference. For me, I see a difference. The difference here being that one is seeking to prevent irresponsible communication. We should not take it as a virtue that people are allowed to just communicate anyhow, even to do things that will endanger our collective peace. So there must be some line drawn somewhere. Now, in the case of the criminal libel law, it was seeking to protect public office holders. And of course, usually it will be the top public office holders, the top politicians, and for that matter, there was this hue and cry, and it was repealed. Now, I would not compare such a provision to the one under discussion now, that is 207, 208, and then section 76, as we said. They are not on the same pedestal. Clearly, they are not. The latter may be abused, and if they are abused, we can talk about that as a different kettle of fish. Because sometimes something may be for a good purpose and then it may be abused. We can talk about that.
All right.
But to say they are the same is a bit of a stretch.
Okay.
To me.
So they are not the same, but do they have similarities?
Yes, they do.
Okay.
It is about speech. And for me, I think rights should have some limits. You should be able to exercise your right, but then it should not be limitless for you to exercise it to the detriment of the whole society.
Okay.
So when it gets to that level, limits must be drawn. And I think Section 207, 208, if they are being implemented properly, we should not be having problems.
Okay, thank you very much, Justine. Let's now get ready to hear Professor Stephen Kweku Asari's rendition on these matters. I'm sure you would have heard him publicly already, but this is the law, where we take our time to give you pure legal education. It is your health law and your legal light. We take a quick break and return to Professor Kweku Asari. You're welcome back. This is the law. It is your health law. It is your legal light. And my guests discussing whether or not criminal libel is alive in Ghana are Efia Amponsamensa. She is lecturer, UPSA Law School. Justine Povara Tarwaja is a lawyer and also a lecturer, a former police officer. And Professor Kweku Asari is KPMG Professor of Accounting at the University of Florida, attorney at law, Florida Bar, and CDD Ghana Democracy and Development Fellow in Public Law and Justice. Now, Prof, let's have your take.
Interesting listening to you and Justine. And it's important to make a distinction. In law, we have what we call the law as facially written, and then the law as applied. Facially written, the libel law clearly differs from Section 207, which is a peace, it's a law to protect the public peace. And Section 208, which is a host law, a law to prevent people from using false information to induce fear and panic in the public. The libel law, of course, is not even, as repealed. Now the information taught is not a public law, it's a private law. If you are defamed, you go to the court to seek a remedy. That's not even a public law after the repeal. So facially, Section 208 is different from Section 207, and the two are different from the libel laws, whether you are thinking about tort or you are thinking about the criminal law which has been repealed.
Okay.
As applied, however, which is how do we apply the law? Well, there's no difference between the application of the repealed libel laws and the misapplication of Section 208 to bring people back into the docket for the things that the law has repealed. The police, when they have invited journalists for saying something that was false, they've always said they've invited them because they are inducing fear and panic in the public. This is palpably false, and this is not the reason why we have Section 208. We have Section 208 to prevent situations like we witnessed in 2010, where somebody sent a text message that there's going to be an earthquake, and you had people actually running to sleep on the streets. That type of host disrupts public life, takes valuable resources away from law enforcement to deal with the situation and should not be countenanced. Every country has a version of that law to maintain public order. In the United States, in the COVID era, people have been sent to prison because they would say that, oh, I went to the grocery shop and I had COVID and I licked most of the products on the shelf. This then induces fear and panic. People do not go to the shop. So I have no problem with Section 207 or Section 208 as written. But as the police are currently applying it, I have a problem because it's a backdoor introduction of the criminal libel stuff that you guys were talking about. And I'm glad that the police seems to be doing a U-turn, because yesterday I read somewhere where the police public affairs directorate had come out and issued a statement in response to what Abronye said about being invited. Abronye had indicated that it was the IGP that personally invited him, which under the misapplication of Section 208, he could have been invited, arrested, detained, and put on charge for violating Section 208. But the police did the right thing. In that case, they didn't invite him. They stuck to the law and the Constitution, and they came out with a rebuttal so the general public can decide on who is speaking the truth. That is the marketplace of ideas. You are allowed to say things, even false things, as long as the false things do not incite fear and panic in the public. You are allowed to say those things. And then other people are allowed to fight back with what they consider the truth. And in that marketplace, rational peoples can distinguish propaganda from the truth. Now, there are other places where you cannot, for instance, make false statements. There are a lot of non-controversial restriction on speech. For instance, we all agree that when you are under oath, you cannot make false statements. That's the perjury law. Yes. That is a justifiable restriction on speech. We all know that you cannot just publish pornographic or obscene materials. That has no social value, and it's a justifiable restriction of that. We all know that there can be all forms of time, place, and manner restrictions on speech. So when people are sleeping, you cannot just go and start beating a drum, disturbing all of them. Or you cannot go to the military barracks and shout, "I'm staging a coup," because of where you are. You cannot go to the airport and shout bomb. These are all justifiable restrictions. So when we talk, people have to listen to us carefully. Right. We are not against limitations on speech. We are against impermissible limitations on speech, unjustifiable limitations on speech, such as the misapplication of Section 208 to bring criminal charges against journalists who have made false statements about so-called big men. The so-called big men have all kinds of remedies open to them. They can go to the NMC, National Media Commission, and file a complaint. They can trigger their right to a rejoinder. They can go to civil court and seek relief by way of tort, and so on. So there is no reason for the state itself to invest resources going after people who have said unpleasant or maybe defamatory things about big men. Let the big men themselves resolve that, similar to how Dampare resolved the falsehood
in a minute, Prof, what will you say if defamatory comments are made about a state agency or institution? What should they do? Because they do not have a right in law to take up defamation suits.
Well, you cannot defame an institution. Defamatory law is a personhood law. You defame persons, you defame the reputation of persons, and then they fight back.
You can defame a corporation. You can cause them so that they will suffer damage in terms of their corporate reputation.
The private corporation has a relief in the form of the regular tort.
Okay.
There's the tort law, there is the National Media Commission, there is the right to a rejoinder. There are all kinds of civil remedies available to a corporation whose reputation has been damaged, that are not available to states.
All right. Thank you very much. Yes, what will you say? He's done a certain distinction, and you were speaking to me backstage earlier about the law as you find it on the face and the implementation or application of the law.
Yes, so when you take the repealed law and then you take 207, 208, on the face of it, it's different. For the repealed law, you have, as long as you publish, you are guilty. Once it's a defamatory matter, even if you didn't intend to or you wanted to, you're guilty of criminal libel. Here, you have three elements. You have a public place, you have the use of those words or that false statement, and then you have the third part, which is provoking a breach of the peace, or a breach of peace is likely to be occasioned. So if you take the first two, then it sounds like criminal libel. Then when you add the third part, it is not criminal libel now. So you have these two different laws on the face of it. Now, how is it being applied? That's, I believe, the issue that we have here. Journalists being arrested for using threatening words in a public place.
Not only journalists, the other guy is not a journalist, for example.
So is a person being arrested for using threatening words in a public place.
For making false publications.
Or for making false publications. Or the person is being arrested for making false publications or using such words in a public place, which is likely to also cause some breach of the peace. So we have to look at all three elements, and they have to be satisfied before you can assume that the person is guilty of anything under 207 and 208.
So do you agree with Professor Kokwa, that the manner of implementation or application or use of these laws sort of in the backdoor manner seem to be reintroducing criminal libel?
So, something like this, there is a redress. There's an avenue that is available to all persons who may be injured by a false statement or insulting words or threatening words. It's civil. It's moved into a private matter between yourself and the person who made that statement. So at what point does the state come in? Why would the state now come in when somebody has made such a statement against your reputation? That is the disconnect that we're having now. So if you introduce the state into it, then the state comes in, because what we learn in law school is that if it is a crime, it is the state versus the person, or is the republic versus the person. One of the first things learned in criminal law. If the state comes in, are we saying now that it's become a criminal thing instead of just a civil?
Yes, sir. So Justine, you were also going into this area where you said, when we come to the application, we can talk about it differently. What are the circumstances that are, the best or best suited for the application of these laws, different from what we are discussing about reintroduction of criminal libel?
We are talking about. If you publish false information in a public place, that will anger people and make it so intolerable to them, to provoke a breach of the peace by them, that they may want to attack you because they just can't stand what you are doing. Then you are the one causing all that trouble. And if the police charge you for that, that typically is the scenario that we are talking about. And then we have the other section 2 that talks about publishing things that will cause stampedes and commotion in the public space. Now, those type of irresponsible and that type of irresponsible communication ought to be criminalized. And
do I understand you to say the best suited circumstances where these laws are applicable is where the things you say or do attract immediate disobedience of law?
Exactly. It is going to trigger something else. You see, yours is like a match you are lighting in a place that is kind of so sensitive, like petrol place type of thing. Now, so you are lighting a match that is going to lead to an inflammation. Now, so because of that type of conduct, that is going to cause that type of reaction in the public, you need to be disciplined to prevent that type of thing. So it is aimed at protecting all of us so that irresponsible communication will not lead to trouble for the public.
So the manner of application presently may look wrong.
Exactly, because it doesn't fit the mold. If you look at the typical scenario, that's why I said when I was in the police service, I was in the legal unit, I joined the police.
Thank you very much. We have just run out of time. My guests have been Professor Kweku Asare, who is attorney at Law Florida Bar, and Efia A. Amponsa Mensah is lecturer UPSA Law School. Justine Poivra Terewaja is also a lawyer and a lecturer and a former police officer. I'm Samson Ladia Yanini. My apologies that we were not able to come to take your views, your comments. We should be able to get back to this the next time. This has been The Law. It is your legal light and your help law. Next week, this time, you will be watching the Ghana Law Challenge on The Law. Have a good afternoon.